Hey everybody, Derek Christensen here. I'm the owner of Legion Law, a premier estate planning and probate law firm in Dallas, Texas. Today I wanted to talk to you about half-siblings and how they are treated differently in estate planning in Texas. But before I dive into that, I wanted to let you know how to reach out to me. You can find me in my email, Derek, D-E-R-E-K, at legionlawpllc.com. Or you can go to my website, www.legionlawpllc.com. So with that, let's dive right in. So I say that they're treated differently, but most of the time they're treated the same. In fact, as I mentioned in other videos, you are totally and completely able to transfer whatever you want to whomever you want, unless you have a spouse, then it's a little bit different. But if you have the right to transfer something and you want to give it to your half-brother or your full brother or anyone else, it does not matter. You can do that under a will or a trust or both. However, if you do not have a will and if you do not have a trust, then the default laws of Texas are going to apply. The default laws state that you must follow them with all rigidity. Rigidity, is that a word? And you must do exactly what they say, the laws say. It does not take into consideration context. It does not take into consideration how much you guys like each other or hate each other. At the end of the day, you must do what it says. So that is kind of tough because one of the laws is actually strangely against half-siblings in the context of dying without a will. More specifically, if I die without a will, there's a specific chain of command, if you will. There's a list of who can receive what under what circumstances. If I die without a will, more often than not, my spouse is going to receive either most or all of the estate. However, if I have children with other people other than my spouse, then there will be a weird division. I've talked about that in other videos. However, if I die without a spouse and I die without children, then there are other people who are entitled to receive assets. Sometimes it's parents, sometimes it's siblings. It really depends on how many parents there are, how many siblings there are, and if you're survived by both or one or zero parents. The circumstances change, but siblings can be involved in receiving assets from your estate depending on how many parents are still alive at the time of your passing. I believe if both parents are still alive, the siblings receive nothing, but if one parent has passed, I think half goes to one parent, half to the siblings in equal shares. I'd have to double check, but either way, this very specific chain of laws leads to siblings. And ironically, well, not ironically enough, interestingly enough, one of the laws state that if you have a full sibling and a half sibling, that half sibling is going to receive half of whatever they are supposed to receive under the law. And then the other half of the half transfer to the half sibling is going to go and get distributed according to all the other full-blooded siblings first. And if there are no full-blooded siblings, then you just treat every half sibling like they're a full sibling. So that's a lot of halves and fulls all of a sudden, but I can give you some numbers. So specifically, if I die without any wife or any children, and I don't have any parents, and I have 3 siblings, technically it's 33, 33, 33. Actually, that's not good math. That's going to get really complicated real quick. Let's go with 2 siblings. So one sibling would receive 50, another one would receive 50% of my estate. However, in these circumstances, if one of those siblings is a half sibling from a different relationship and my parents got remarried and had different children, then in this circumstance, my full-blooded sibling would receive 50 and my half-blooded sibling would receive 25 because his 50 is cut in half. And then that remaining 25 is going to my full-blooded sibling again to make it 75-25 split between my full-blooded and my half-blooded brothers. So it's a strange situation to be in. It's not ideal for sure. And again, if I just simply had a will and I said, all right, 50-50 to each sibling, we wouldn't even have this conversation. So really, we're only concerned about this in the circumstance that there is no will and there are no spouses, no parents, and no children to worry about. Now, this admittedly is very rare to happen, but it is still a circumstance in which blended families, people from different marriages are treated worse in the estate planning world in Texas than other people who just have a nuclear, altogether normal family. Whatever normal means nowadays. But either way, it's all good, and we are trying to figure that out. So if you are worried about your half-siblings possibly getting the short end of the stick, then you will want to make sure that you have at least a will, if not a trust, in place to make sure they take care of all your assets whenever you pass away. So with that, that's pretty much it. So don't be a half sibling, in other words, because otherwise you're going to get half of whatever you're supposed to get. But if you guys have any questions on that or anything else related to estate planning and probate, feel free to reach out to me. I always respond to emails, and I'd be more than happy to be a resource. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com. So with that, thank you so much for watching, and have a great day.